borders between a denial, a violation or infringement of a right, a threat to a right, or fundamental freedoms. We address you on the basis that the section under which this charge sheet has been premised, that is section 94, subsection 1, was enacted in 1930, with the commencement date being the 1st of August 1930. It follows therefore, Your Honor, that with the enactment of the new constitution, the old EPP who has brought us here this morning ought to have been alive to the provision of section 7 to the 6th schedule to the constitution. Section 7 to the 6th schedule, Your Honor, to the constitution provides that all laws that were in effect before the effective date shall be read with the necessary modification, adaptation, alterations, so as to bring it into conformity with the provision of the Constitution. And while I am not inviting you to look at the constitutionality of that section, I am inviting you to look at whether or not the application of that section falls within the provision of section 8 of the Magistrates Court Act. I want to make it clear so that my learned friends on the other side may understand that I'm not invoking your jurisdiction to determine the constitutionality. I'm invoking your jurisdiction to determine the applicability of that provision. Therefore, in that sense, Your Honor, section 94, subsection 1 must be brought within the ambit of section 7 to the 6th schedule. And the reason why the drafters of the Constitution made a proviso to save the existing laws before the effective date was to make sure that, Your Honor, that granted the circumstances that Parliament is not able to address all laws supposed to bring it to conformity, that the application of such a section may not result into violation of a provision under the Constitution. That is the reason why we have the clause saving the existing laws before the effective dates, and hence the enactment of section 7. Having said that, Your Honor, section 3 tells you that you must address yourself to Article 10 of the Constitution. And what are you addressing yourself to Article 10? Article 10, subsection clause 1, provides that Article 10 binds all state organs or even persons whenever any of them is either implementing the law, legislating the law, or formulating a policy. In this case, Your Honor, you are implementing the law. And therefore you are bound by the provisions of Article 10, which lays down the national values and principles of governance. Among those values, Your Honor, is a value of human rights. That human rights binds you. And that is why section 8 of the Magistrates Court Act, in cognizance of the fact that you are bound by Article 10, has deliberately given you that jurisdiction. Because it is not possible, therefore, for the Constitution to say that Article 10 binds you holistically without any possibility of waiver, and then you are told that you cannot determine a threat, you cannot determine a denial, you cannot determine a violation. Having said that, Your Honor, Article 10 also invites you to look at the rule of law. And also the question of social justice. And the principle of equality and equity. That is therefore to say, Your Honor, and I want to associate myself with the submissions made by senior counsel, is there equality, equal application of the law granted the circumstances and the summation that he has made, because I consider them to be legal arguments. Number 2, Your Honor, the application of Article 10 invites you to look at the question of discrimination and Article 27. Because Article 27 falls within Article 10 where you are mandated or commanded by the Constitution to observe human rights. And therefore to say that, Your Honor, when you retire to make our application to the objection of taking plea, this plea does not conform to the dictates of the new Constitution. That is one ground of the objection. That it is not possible for you to ask Honorable Jane Kihara to make a plea that will be unconstitutional for failure to conform to the dictates of Section 7. That's one limb of our argument. The other limb of our argument is that the same does not disclose an offense. Those are two grounds. That if she was to make or she was to plead to this offense, one, she does not even understand what offense is actually facing her. Because even if we were to make an assumption for purpose of argument that Section 94 subsection 1 that it was in conformity with the Constitution, is it just the proviso that the Jane Kihara, Honorable, offensive conduct offensive conduct conducive to breach of peace? This proviso of the law must be backed by particulars that speaks to that offense. We therefore submit that the particulars pleaded herein do not speak to the purported or to the alleged offense. These particulars falls within the provisions of Article 33 of the Constitution, the freedom of expression. To admit this charge, therefore, Your Honor, this court would be rising up to the occasion of limiting her rights. And the limitation of these rights, Your Honor, under Article 24, the court has created a test that it must be justifiable for you to limit. It must be justifiable in a free, open, democratic, and civilized society. If that then would be the test and granted her status of members of parliament, would the taking of this plea not amount to the limitation of that particular right? And that right be a justifiable one in a democratic society, a free society such as this one, a civilized society such as this one? That was not the intention of the legislation. That was not the intention of the enactment of the 2010 Constitution. And then even if she were to plead, Your Honor, even if she was to plead that she made these remarks, Your Honor, would this conform to the provision of Article 50, Clause 2, Paragraph 4? And that's the doctrine I love speaking about, the doctrine of nurum crimen sine lege, that you shall not be charged of an offense if the offense itself was not known in law. And the argument that the offense is not in law is due to the fact of the jurisprudence that has emerged following the enactment of the new Constitution vis-a-vis Section 7 of the 6th Schedule. That had it been to be brought to the conformity to that provision, this offense would not be existing in our books of law. If we had a proactive parliament, and not a parliament like the one that we currently have, this perhaps would have ceased being good law in our books. But granted the circumstances that Parliament itself has not amended this provision, that Parliament is too lazy to bring it in conformity with the provisions of Section 7, are we left helpless? Is it therefore that the DPP has the liberty to charge any other person just because Parliament has become negligent? Parliament has refused to legislate? You are called upon by Section 8 to rise up to the occasion in the event there is ineptness on one part of state organs. And besides that, let me invite my learned friend, Mr. Kira. Article 10 places you on the same pedestal with the Parliament. Because this court and Parliament is bound up by that provision. So where there is ineptness and negligence on the part of Parliament, the court of law can rise up. In any case, the application of Section 7 vis-a-vis Section 8 of Section 7 to the 6th Schedule vis-a-vis Section 8 of the Magistrates Court Act can only be applied by this court, not Parliament. So we invite you, Your Honor, to find that there is no offense that has been disclosed by this particular charge sheet. The same is meant to achieve ulterior motives other than that which is contemplated to protect public interest. It is meant to preserve personal egos. It is meant to preserve at a certain equilibrium for which you do not understand personal emotions. Unfortunately, this is a court of law. If anyone feels injured by these particular statements, the recourse is not before you. The recourse is not to criminalize utterances that are constitutionally protected. When you retire, you look at Article 19, 20, 21, and 27 of the Constitution. I invite my light friends.
Sorry, especially those provisions, the last was Article?
Yes, Article 10, Article 19, Article 20, 21, and 27. And finally, Article 33. But also, look at Section 89 of the CPC, when a court can decline to admit a charge. Allow me just to read it as I invite Mr. Kirago. That is Article 90, Section 98, 89, subsection 4. The magistrate, upon receiving a complaint or where an accused person who has been arrested without a warrant is brought before him, shall, subject to the provisions of subsection 5, draw up or cause to be drawn up, and shall sign a formal charge containing a statement of the offense, with which the accused is charged unless the charge is signed and presented by the police or the ODPP. That has been done. When it is brought before you, Your Honor, then you are supposed to invoke subsection 5. Where the magistrate is of the opinion that a complaint or a formal charge made or presented under this section does not disclose an offense, the magistrate shall make an order refusing to admit the complaint or formal charge and shall record these reasons for the order. I invite Mr. Kirago.
And Your Honor, that is a perfect starting point for me. And I'll be giving you reasons why we should not admit this charge. You know, this charge is drawn, and it is alleged that the person before you has done something contrary to Section 84, subsection 1 of the Penal Code. And Your Honor, that is the section which I've opened. That section, and if I may just read the words that are in the charge sheet, that Jane Jerry Wajiro Kihara, on 8th day of July 2025, at Nairobi City within Nairobi County, being in a public gathering, uttered the words to read. Now the words are there, the paragraph is there. it concludes, with intent to provoke breach of peace. So, I submit that that charge, as drafted, does not disclose any offense under section 94, subsection 1 of the Penal Code. These are the reasons you know. That section reads, a person who in a public place or a public gathering uses threatening, that's one, abusing, that's the second one, or insulting words or behavior. So, the operative words here are, those words must either be threatening, there is no suggestion that she used any threatening words, abusive, it is not alleged she used abusive words, or insulting words or behavior, it is not suggested that she used any insulting words. And then that is when an offense is constituted. So the charge that is before you does not have threatening, abusive, or insulting words or even behavior that would go on and cause breach of peace and all that. So basically, the offense that is before you is hollow. The other part of the section is just saying how minor that offense is just a fine of 5,000 shillings.
Can you address the other element?
Yes, I'm coming to that. I just caught my eye in the fine, which is 5,000 shillings. So, then, with threatening, abusive, or insulting words or behavior, there's no suggestion that has taken place, with the intent, one, to provoke breach of peace. That is the one that has been taken. So that for you to have an offense where the intent is to provoke breach of peace, those words or that conduct must fall within the three parameters, or any of the three parameters that I mentioned. What is before you does not fall under any. Under subsection 2, the Act then defines what is a public gathering. And what you will find is that one situation where there is a gathering is when there is any meeting. So basically, when a charge reads a public gathering, a prosecutor must take the charge to what kind of a gathering. Is it a meeting? Under paragraph A. Gathering or concourse of 10 or more persons in any public space. So you're not being told, were they 2 people? Were they 1? Were they 3? Because the minimum number is 10 or more. And it must also be in a public place. This charge does not say the public place or any place. We are just being told in Nairobi. All of us in Nairobi. Yeah, even here is in Nairobi. So, which is a public place. So, that way, the offense is not disclosed. Paragraph B. Any meeting or gathering which the public or any section of the public of more than 50 persons are permitted to attend or do attend, whether on payment or otherwise. There is no suggestion, it has not been indicated whether there were 50 people, whether these people paid to be there, they didn't pay to be there. So what is Honorable Jane supposed to defend? These particulars are not in the charge. And finally, the other situation is the paragraph C. Any procession in, to, or from a public place. Any procession moving in or out of a public place. We are not told that these words were uttered in the constitutions. When a charge is brought before you, under section 94, under section 134 of the CPC, one thing that should stand out is the following: that every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving a reasonable information as to the nature of the offense charged. The information that is contained in this charge, Your Honor, is insufficient under subsection 1. It is insufficient under subsection 2 of section 94 of the Penal Code. Would it be right then if I shift to that point? Your Honor, when a charge, and the section which I have just referred to, that is section 134, is indeed the section that implements the provisions of Article 50, sub-Article 2, paragraph B of the Constitution, that provides that every accused person has a right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer it. The charge that is before you does not have sufficient details as defined in the implementing statute. So if she goes ahead and pleads, the judge has brought before you, it will be a violation of Article 50, Article 2, paragraph. And important to mention, Your Honor, that under Article 25 of the Constitution, and for emphasis, I want to read what it says, that despite any other provision in this Constitution, the following rights and freedoms shall not be limited. These are rights which cannot be limited. And one of such is the right to fair trial. That is paragraph C of Article 25. The right to fair trial is the one that I had talked about under Article 50. So you are then placed in a position where you have a charge that is in contravention Article 50, and you're being asked to allow a person to plead to those charges. Your Honor, decline that invitation. And Your Honor, I do not want to talk much because before we came here, we were before you again in another matter with the same prosecution team and Mr. Mageto for Honorable Ndegwah. And yesterday we slept very late because we were at the DCA headquarters to deal with an issue of Honorable Mutembei. And now we went to the other day, then yesterday we were dealing with Objection. And no, so that Your Honor, I do not want to tire you because we also very stretched. But the context of that is that there is a pattern, and this court should rise to the occasion and see what is happening and uphold the Constitution, and that will be done. And I invite my other friend, our chairman, Mr. Ndegwah, to make something.
No, Your Honor, that is not the introduction they used to our chairman. This is our chairman of Gachagua, which is an organization of about 6,000 lawyers. So you cannot just give that introduction, please.
Thank you. Well, it's another thing. You're the chair. Let us get.
We have an association which has about 8,000 lawyers practicing in Kenya, others in Kenya. It's called the Gachagua Association. Very many lawyers.
What he is not telling you is that he has now incorporated our cousins from Kenya South.
Guys, our Thank you. Thanks for that introduction. Your Honor, again, my name is Wanjohi, and allow me to concur with what my senior, Mr. Sian Kara, said